Go ahead, counsel.
Doctor, would Eric have experienced any pain and suffering as a result of this crash?
So I think he probably would have, but the amount and time that was present, I can't tell you.
Okay. Does the coroner's report detail how he was disfigured as a result of this crash?
Yes.
Okay. At this time, Your Honor, I seek to admit Exhibit 36.
Okay, pending the objection that was already made, we'll make a better record of it outside the presence, but it'll be admitted.
Okay, thank you. Can we pull up Exhibit 36-004? In the radiograph section, please. Doctor, let me ask you this. Does this detail injuries that the other records, the Sunrise Hospital records, the AMR records, and the Mercy Air records do not detail?
Yes, it does.
Okay. I'd like to go through these line by line so you can explain to the jury exactly what these detailed injuries are, if you don't mind. Let's start off with the first one. It says head reveals a probable fracture of the left temporal bone and a fracture of the right lateral aspect of the mandible. Do you see that?
Yes.
What is that?
The temporal bone is part of the skull. It's lateral. It's located around the ear in this area here. The mandible is part of the lower jaw, and it's from here to here. That would be on the right side.
Is that from the motor vehicle crash?
Yes.
And next thing, it says a probable fracture of the base of the skull is observed. Do you see that?
Yes.
What is that?
The base of the skull is the bottom of the skull. There's a small hole in it where the spinal cord can go down out of the skull. So that base of the skull is the supporting part of the brain in the skull itself.
Okay. Next, it says chest reveals fracture of the right clavicle. Do you see that?
Yes.
What is the right clavicle?
Clavicle is the collarbone here. And the scapula fracture is the posterior part of the shoulder. And the first through eighth ribs, you have 12 ribs. So 8 of them were fractured on the right and 3 of them on the left.
All the result of the motor vehicle crash?
Yes.
Where it says there, right to left mediastinal shift. What does that mean?
So the mediastinum is the space between the 2 thoracic cavities. It contains the trachea to breathe, the esophagus to swallow, the aorta and other major vessels of the body that come off of the heart, and it also contains the heart. When there's a right to left shift, there is some amount of fluid in the right chest that's so significant, it's pushing the mediastinum to the left.
Did he also have fractures the ribs on the left side?
Yes, the
Okay.
first 3.
Okay. How many ribs on the right side and how many ribs on the left side were
12
fractured?
in each.
Sorry?
12 on each.
How many were fractured on the right side? How many were fractured on
8
the left side?
fractured on the right and 3 on the left.
Okay. A thoracic spine dislocation, what is that?
So when you have a dislocation, you have a disruption of the major ligaments. There's multiple ligaments of the spine. And a disruption of those ligaments creates an instability where the spine translates or is moved forward, backward, or to either side. So anterior, posterior, or lateral listhesis. And that is dangerous because the spinal cord sits in that bony canal, and when there's a dislocation, the spinal cord is injured.
All the injuries we've gone through so far, those all are a result of the high velocity crash in this case?
Yes.
Okay. Next, it says radiographs of the abdomen reveals prominent gaseous loops of bowel. What is that?
So bowel contains fluid and air, and the prominence is consistent with, but not diagnostic for an injury. But the prominence does play some fact. It's non-specific with respect to intra-abdominal injuries.
Okay. There's another rib fracture there?
No, it's the same as was seen above.
Same
This
one.
is just seen separately on abdominal x-ray.
Anything else that we haven't gone over that was a result of this crash?
So there's also a lumbar spinous process. The spinous processes are the most posterior elements of the spine, and 1 through 3 in the lumbar spine are fractured. There is
That's a result of the
thoracic spine, also in the thoracic spine. There's a dislocation there as well, which would have been the same. Probably that occurred here. Surgical clips are identified in the pelvis, probably from a prior procedure.
what, other than the surgical clips, everything else you mentioned so far is still from the crash?
Yes.
Okay. Anything else on there from the crash that you see?
Not from the crash, no.
Okay. Do these all together, when we put them together, do they all consist of the multiple blunt force injuries that caused Eric's death?
Yes,
And they all are from the trauma of this high velocity motor vehicle collision?
correct.
Okay. I just want to go to one more page on the coroner's report. Can we go to 36-006, please? Under, can you make the toxicology results big, please, Joe? Was the toxicology for Eric Echevarria negative?
Yes, it was. There was
Okay.
no evidence of alcohol or typical drugs of abuse. All of those screening was negative.
Thank you. All right. Just want to warn the jury, I have to show some pictures. I apologize. I'm going to show these pictures. We're going to go through them relatively quickly, doctor.
Okay.
I just want you to explain what we're looking at, okay? Let's just pull up the first one, 7-0289. Is this Mr. Echevarria in the hospital?
It is.
Okay. Can we go to 7-0290? What are we looking at? Just can you explain the bruising injuries that we're
Sure.
looking at?
There's dried blood throughout on the arms, the chest, the face, and the neck. The dark circles at the eyes is called raccooning, and those are indicative of a traumatic brain injury or a skull fracture. There's an endotracheal tube present and taped and secured so that it wouldn't move. There are EKG pads throughout the chest and abdomen. There's a tube on each side. The one on the left is better seen. That goes directly into the chest and is hooked up to a container that is off of the table. The swelling about the face and neck are due to injuries, and there does appear to be a little swelling in the chest as well. There's abrasions, bruises all over the body.
Where did he lose 40% of his blood from? You said he lost 40% of his
Well, I
blood?
said that was my estimate.
Okay. Where would he have lost it from? Is it from the brain? Is it from the abdomen? Is it from
But
everywhere?
you don't know, not in the brain,
Okay.
but in the abdomen and chest.
Okay. Let's go to 7-0291, please. Anything different on this?
No, it's just a close-up. It looks blood. There's blood in the ear. Again, we had noted that earlier. That blood from the nose and the ears is significant for a skull fracture and correlates highly with a brain injury.
And 7-0292, please, Joe. Anything different here?
No,
Okay, and 7-0293. Anything different here, Dr. Hirschfeld?
just it just shows the back part here, and the blood pools downward, and you're seeing a lot of pooling of blood. That's all blood that you're seeing on the stretcher, and that's basically it.
Okay, can we take it down, please, Joe? Thank you. Any doubt in your mind that the crash caused all these injuries you went through, doctor?
None.
Okay. All your opinions today have been to a reasonable degree of medical probability. Thank you.
Good afternoon, Dr. Hirschfeld.
Good afternoon.
My name is Stephanie Zinna. I represent Zaon Collins. Thank you for your testimony. I'm not going to be here we're not contesting that the crash did not cause Eric's death, nor are we contesting that the medical bills were not reasonable, so I'm not going to be asking you any questions about that.
Okay.
Because there is a measure of damages that I have to discuss, I just have a few questions, and I'm not trying to be indelicate here. But Eric was unresponsive after the crash, correct?
Correct.
And can you explain again the Glasgow coma scale?
So it's a measurement, which first appeared in the 1970s, in Scotland, obviously. And, it measures, the best eye-opening, the best verbal response, and the best motor response. On a scale from 1 to 6 for motor, 5 for verbal, and 4 for eye opening. So your highest score is 15. 3 is the lowest score, and as I testified to earlier, there's a high mortality and morbidity for patients who survive that from a very low score.
So with the Glasgow coma scale of 3, was Eric ever conscious?
So conscious, no, that it was ever documented, but we don't know the period of time from when the accident occurred to arrival of the fire department and the multiple minutes of extrication that it took. That was never documented, so I can't tell you that.
Okay, so you don't have a basis one way or another
I-
to speak for that time.
I do not.
Did you note anywhere in your report where Eric would have been conscious or?
So conscious, no. The ability to feel pain that in patients with coma has been studied in the medical literature. And
And I want to stop you right there, doctor, and I'm sorry, but did you note anywhere in your report that that was the case here?
I did not.
Thank you very much. Nothing further.
Okay, hold on, Mr. Watson.
Nothing from me, Your Honor.
Okay,
You want to explain something about the pain in coma? Can you explain?
Objection, Your Honor, outside the scope, Black's Foundation.
response.
It's within the scope of, she asked about unresponsiveness, and he started to talk about coma. So it's within the scope of my redirect, Your Honor.
Overruled. Go ahead.
Go ahead.
So the medical literature has dealt with patients in a coma or with GCS 3 scores. When a patient is unconscious, they cannot verbally or by way of withdrawal or grimace or other measures respond to a painful stimuli. That doesn't mean they're not having a painful stimuli. And so the literature advises emergency room doctors and intensive care doctors on how to manage pain in comatose patients, because it's universally felt that some level of pain is felt. And so we are trained on how to manage that pain. That's the best I can say here.
Is that why you believe more likely than not that Eric would have experienced some degree of pain and suffering?
Objection, Your Honor, outside the scope, Black's Foundation.
Just joined, that was not part of his report, Your Honor.
You already testified to it on direct and there was no objection, Your Honor.
There was testimony on direct, but let me take a look at the report. Oh, are you saying that it's not in the report, but that you
I think they
had the
opened,
information said in direct testimony
yes,
already? So
it was already on direct, with no objection, and they brought up the consciousness in their
to
cross-examination.
argue you opened the door. But, the testimony previously that has no objection is what it is, though.
In Your Honor, I did object
He objected,
at the bench.
correct.
That was not an objection, the specific question asked, Your Honor, that was
Wait.
different.
Okay, then and I did not think we were talking about the same thing at the bench conference. Okay. Can you repeat your question, please? Don't answer it yet, please, though, sir.
Yes, ma'am.
Doctor. Thanks, go ahead.
My question, I believe, was, is that why you opined that Mr. Echevarria likely experienced some degree of pain and suffering before his death?
And your objection is that that's not his report, right?
It is nowhere in his report, Your Honor, and I don't believe his testimony met the burden regardless.
Okay. That is gonna be sustained. I'm not finding it in the report either. Do you see anywhere in the report where, and look, the testimony during the direct is what it is at this point? If it was that, then that's what the testimony direct was, if it was unobjected to, but, do you have anything in the report to support that question?
No, Your Honor.
Okay, thank you. Go ahead.
All your opinions still to a reasonable degree of medical probability
Yes, they are.
on a more likely than not basis,
Yes,
including all your opinions on direct examination.
yes.
Thank you.
Okay. Anything else, defense? Okay,
No, Your Honor.
any questions from any of the jurors? One question per sheet, please. I read it exactly as it's written. Thank you. Come on up, counsel. So, doctor, here are the questions. And look, if your question was not asked, you're not to draw any inference from it. There's certain reasons why the questions are not asked, and unfortunately, we're not at liberty to describe that or explain it. But your question might be answered by another witness later on. That might be part of why it wasn't asked. Okay, so doctor, the first question is, what chances do patients with agonal breaths and GC 5-3, I think, did GC 5-3?
3.
Oh, GC3
Yeah.
have for survival if these were initially reported at the scene of the accident? So the Glasgow Coma score.
So the agonal respirations, may or may not have a correlation with survival. The known statistics for correlation is a GCS 3, even 5 is significant, but the mortality rates in the literature for a 3 that does not recover quickly in the first several hours after evaluation and treatment is 50 to 80%. So their survival is no more than 50 to 20%.
Okay, the next question, was the injury to the left side of the skull caused by slamming into the brick wall or by Mr. Echevarria's own vehicle?
So the impact at such a high speed almost certainly caused a force significant enough to slam Eric's body to the left and impact first that side of the car. And then an opposing force would have come back this way on the left side when the solid brick wall was encountered. So 2 different impacts. The initial force throwing him against the car on the left side, and then a counter force when it came to rest, forcing him back the other way.
Okay, thank you. Plaintiff's counsel, do you have any more questions?
Just one brief.
Of those, yeah, go ahead. Excuse me.
Based on your review of the records, doctor, did all the medical providers do their best to save Mr. Echevarria?
Yes.
Thank you.
Defense counsel, any additional questions?
No, nothing further.
Okay. Any more questions from any of the jurors? Okay. Thank you very much, Doctor. You may step down. Now might be appropriate time to take a short break. We'll be taking our afternoon break now. It'll just be a 15-minute. So it is 2:59. I'm gonna ask you to come back at 3:15. You're instructed not to talk with each other with anyone else about any subject or issue connected with this trial. You're not to read, watch, or listen to any report of or commentary on the trial by any person connected with this case or by any medium of information, including without limitation, newspapers, television, internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, or using reference materials. You're not to conduct any investigation, test any theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in this case. You're not to form or express an opinion on any subject connected with this trial until the case is finally submitted to you. Okay, with that being said, you are on a break until 3:15. Thank you. Okay, everybody can be seated. I think the door's closed, right? Okay. Anybody want to make any additional record or clarify anything that was done at the bench?
Not for plaintiff, Your Honor.
Yeah, sure.
Go for it.
So first I want to start off with the testimony regarding the pain and suffering. It was not in his report. We believe the bench conference was directly as to that, which is why we were objecting to the coroner report coming in, as well as again, reiterating our objection to the photo. So I would just request that the jury be instructed to disregard the doctor's testimony regarding pain and suffering. I also have an objection now because the coroner's report has come in through this witness and he extensively testified to it over our objection that the coroner not be allowed to come and testify. It would be duplicative and cumulative at this point. And then for the photos that were shown, I renewed my objection to those photos, and then the testimony bore out that we had repetitive photos. The doctor had nothing new to say about those photos. They were just overly prejudicial and inflammatory. And then finally, the second juror question that we objected to at the bench that called for a biomechanical opinion, and that's what we got from him. We got a biomechanical opinion that lacked foundation. And for those reasons, I would request that the jury be instructed to disregard.
Okay, response.
The objection was not regarding the pain and suffering testimony, Your Honor. Objections need to be contemporaneous. So that's, I mean, that by the rules, that should stand. Whether or not it's in the report. So I think that's fair game because they didn't object contemporaneously. As far as the coroner, we probably don't need the coroner now because we got the coroner report in through this witness.
Oh, so you're not planning on calling the coroner anymore?
I'd just like to talk to Mr. Chu just briefly and just think about it, but probably not, I would say.
Okay,
If I can just have the opportunity to discuss with him.
okay.
And I can't, regarding the biomechanical, I don't think it was a biomechanical opinion, Your Honor. He's testifying based on where the injuries were on the head and what he knows about the scene of the accident, because he reviewed all the pictures. So I don't think that was technically a biomechanical opinion. That was just an opinion on where the injuries were, in light of what he saw at the scene, based on the pictures.
Okay. Additional comments from defense since you're.
As far as the record at the bench that we made before that, we noted that pain and suffering. He was never conscious. That was not something that he could have experienced based upon the doctor's testimony at that point. So we certainly did address it at that bench conference. Counsel was permitted to then ask the question. So I'm not going to jump up and object again to a question I just objected to and got overruled on. But the biomechanical, the last comment by the doctor was absolutely a biomechanical opinion. He was talking about the forces and the whiplash and going from one direction to the other and what his head would have hit. That clearly was outside the scope and severely weighted into
Is
biomechanical.
there an argument that his head was injured in some other way?
No, Your Honor, but at the same time, it was just inflammatory and it was outside his scope, right?
Okay.
So we let a lot of that go because we're not arguing causation, we're not arguing those damages. And, you know, there has to draw a line somewhere. We're already having this is not easy testimony, these are not easy pictures to hear. So we're treading a line between what is overly prejudicial and what isn't, with the knowledge that the jury needs to hear some of these things. So when we get into opinions like that, well, the doctor is opining the car hit this wall and then swung back and did all of these things, that paints a gory picture for the jury that they didn't need to hear and was unexpected and unanticipated and lacked foundation from this particular witness.
Okay. So these are two different things. I'm gonna deal with them as two different things. As for the pain and suffering, I didn't hear the same thing you heard during the direct about, I understood what you're saying, that he's unconscious, but I'm not sure if unconscious equals no feeling, no pain. And maybe I mean, am I being crazy? Is there a thought that it does that?
Report either, so unconscious, just in a common Glasgow coma scale of 3 means
Yeah,
that is the lowest possible response. You are not responsive to anything. You're not responsive to painful stimuli, which is when they actually hurt you. And if you're not responding to it, how are you feeling pain and suffering?
well, okay, but not responding does not mean that you don't feel.
But he also didn't include that in anywhere in his report, that I've examined these studies that say, well, if even in patients that are showing a Glasgow coma scale of 3, we do have some indication that they might have some pain and suffering. We don't have that in his report.
Well, no, but there was all these questions about the Glasgow coma scale, okay?
Right.
And then, and him defining it and what the reaction was. And like I said, I didn't hear the same thing you heard, or maybe we think differently. That's very possible too. Just because someone's not responding to pain stimuli doesn't mean they're not feeling pain stimuli. Like there's plenty of people in this world that they don't necessarily respond in a normal way, but they are in fact feeling it.
Well, if that was the
No?
doctor's opinion, and I understand where your honor's coming from, if that was the doctor's opinion, then it needed to be in his report, and it wasn't in his report, because I don't believe that that would be a common sense extrapolation from anything that he did opine to in his report. And in fact, his report was just limited to the cause of death and the reasonableness of billing. So expecting him to go off into that area with the medical records showing what they showed about Mr. Echevarria's conscious state, that was impermissible.
But if there's no extrapolation, there's no extrapolation either way. There's no extrapolation that he doesn't feel anything. There's no extrapolation that he does feel something. And there was an extrapolation from your side, at least as I understood it, that he didn't feel anything. And then you started asking him questions about that, which I understood why you would ask the questions, because I think you thought you were going to get the answers that yes, he doesn't feel anything if he doesn't respond to it. And then he gave answers saying, I thought what he said too was that there was even like a 50 or 80% chance that the person was going to die after that kind of a score. But I mean, that also leaves the conclusion that there's a 20% chance they live, I guess. Like that's the low end. Am I misunderstanding
Right, that's
something?
correct, but it does, that doesn't correlate with pain and suffering. And when pain and suffering that the decedent would have suffered, or perhaps would have suffered between the time of the death, is an actual category of damages.
Okay.
Wrongful death
So
action,
what
which
do
is
you want
why
me
it
to-
becomes an issue.
What instruction are you requesting I give?
I'm requesting an instruction that the jury be, that the testimony from Dr. Kirchner be stricken as to the decedent's pain and suffering. And they are, there has been no testimony, or they are not allowed to consider any testimony that the decedent may have suffered between the time of the accident and his death.
Okay. What's your response to that?
Your Honor, the bench conference defense counsel discussed consciousness.
Yeah.
I did not hear the words pain or suffering during that objection, during that bench conference. I do not believe those are brought up at all. I hope the bench conferences are recorded. I know some departments are able to record them, some departments are not.
We've asked for them to be recorded in here. I think they're getting recorded. Stephanie, are you able to hear them and record them, or do you know?
They haven't been bad.
We're not gonna-
And I don't mean to jump in, but in my review of the daily, they haven't been bad.
Oh, you could hear them?
Yeah.
Okay, so they are getting recorded, it sounds like.
My understanding of the objection of the bench conference was in respect to the photos, that it was becoming cumulative and it was becoming because the coroner's report and everything else. So, and I do want to point out, Dr. Hirschfeld does use the word suffered in his expert report. If you look at the last page of his expert report, it's 1, 2, 3, it's the third paragraph up, the longest paragraph. It's the last sentence. It says a redacted coroner's report detailed the significant and multiple blunt traumatic injuries suffered by Mr. Echevarria, which were cumulatively and causally fatal. So the word suffer is in there. Second of all,
Where are you reading from right now?
sorry.
Again, just repeat it. Is it page
Sure.
61?
Yes,
Uh,
Okay.
It's the paragraph right before the
Oh,
paragraph.
I
that
see what
says
you're
in
talking about.
conclusion.
The last sentence, detail the significant multiple blood force traumatic injuries suffered by Mr. Echevarria.
Right.
Echevarria, which were cumulative and causally fatal.
So it's a twofold argument. The first is they didn't object to the question. So objections need to be contemporaneous. I think it was waived. Second of all, even if it was objected to, I think there is enough in the report that he could give the very limited, very brief opinion that he gave. And it was extremely brief. And the last thing is, Your Honor, defense counsel brought it up on cross-examination. And what she asked was, how could he have pain? Something along the lines of, and I apologize, I'm paraphrasing. If I get the exact wording wrong, please forgive me. Something along the lines of how could he have pain if he was unconscious? And I remember him then saying, well, there's this evidence that people in comas, they still give them pain meds because we know they probably experienced some sort of pain. So I do remember that testimony. I think it's fair game, Your Honor. It's in evidence. There's no reason to strike it. There's no basis to strike it. It'd be extremely prejudicial if it was stricken at this point. I think based on those three things, I think it should stand. And each of those stand on their own independently.
Okay. I'm not gonna strike his comments about whatever pain and suffering that decedent did or didn't suffer, because I'm not even sure that they were clear. That he was saying clearly that it's known that pain and suffering, that he was feeling anything. I thought, what I heard him say on the stand is that it's unclear if people that are in comas or have those low scores can feel something. So I'm not gonna strike that. And I think even if it isn't okay, I think the door was opened by questions the defense was asking him during the cross. Now, as for the biomechanical opinion objection, which, as I understand it, you're objecting to the answer at the end, right?
Correct.
Okay, I thought his answer was gonna be different at the end. I thought he was gonna talk specifically about, like, when I saw the pictures of the body and looked at the medical records, I saw injury to his head that appeared to be caused by whatever. But instead he did give a biomechanical analysis. So I am gonna strike his last answer. But I'm not even 100% sure where that started. How much of that can you read back to me, Stephanie? If we take a break, can you, you're doing dailies? So you're getting the dailies, Miss Zinna. And I mean, what do you want me to do? Read it again and say strike that?
I'd rather you not read it again, maybe when they come back in, maybe say something along the lines of, we weren't anticipating the doctor to go down that path with that question. And because it waded into territory, he is not qualified to opine onto, as to, we instruct you to disregard it.
Okay, what are your thoughts on that? I am gonna give it, I am open to giving an instruction. I just don't like any of the suggestions that are in front of me right now. With the alternative of reading it again, which I don't think you like, and saying strike that. I mean, what I'm inclined to do, and you guys can work with one another to figure out if you can agree to something like this. If not, then I'll probably just give it to say that he was a medical expert and any opinion he gave as to a biomechanical cause of the accident, they're to disregard. Now, then the question becomes, do they understand what's medical and what's biomechanical? And I don't know the answer to that. But you guys can both say in your closing, he was a medical expert. He was only allowed to opine, or he opined as to this, and you can say in your closing, the judge instructed you to disregard the biomechanical opinion he gave. I don't know if you want to bring more attention to that, but I'll let you both say that. Because there's where we're at. I did not expect that answer to be that. But the only way we figure out what the answer is before it actually comes out is if we remove the jury, he gives the answer, and then we bring them back in. And frankly, I think that that is not an effective way to do a trial. Oh, yeah, can you, or can we just mute one person, or we have to mute the whole thing? We have to kick her out because she's a witness, right?
Okay, I can
If
have
she's not a party.
our office reach out and tell her to log out until.
Yeah, or at least turn it off, like turn off the sound or what.
I'm fine. Okay with that.
Everybody okay with that?
Yeah, I think we're nearing the end.
Okay, hopefully no one online thinks that we are unfairly closing a courtroom. But if they have a problem, the alternative is come in person and that won't happen. There's no way, I think, to just mute one of them, right? We have to mute all of them?
I muted all of us.
Okay. Oh, you have to mute us for all of them.
You have
Okay.
to mute us for all of them.
So I'm open to giving instruction like that, where he's a medical expert and any opinions he offered about that go beyond medical, including an opinion that was offered at the end regarding a biomechanical analysis should be disregarded.
Can we just, and I like that suggestion, Your Honor, but could we just maybe give them a little bit of what that means? Like, he gave a biomechanical opinion
Write
as
one up.
to.
Yeah,
Okay.
write one up. Write it up, go to opposing counsel with it. I know you're not waiving your right, you still have an issue with me giving any instruction at all, but write one up and let's do that. They're supposed to be coming back from the break in a minute. Do you want to try and do it now?
I can do my best shot. Did we want to talk about the coroner, or do you want to wait until counsel figures out if they're gonna
Do you
call?
want to talk to one another while she's working on this off the record?
Judge, I think we're just confused, because the objection was to the last question, and now we're setting all biomechanical opinions or.
The issue is gonna be, and this is where we write one up and you say it's just to that last answer.
Oh,
It
okay.
just pertains to that last answer given. I want to be clear. I'm only making a ruling and I thought the objection was only to that last answer, correct, Mr. Watson? He's shaking his head yes.
correct.
Ms. Zina's shaking her head yes.
Can I say something briefly?
Yeah.
What I'm confused on is how that testimony is somehow prejudicial to the defense. Because everyone agrees the crash is what causes them to go into the wall. So I don't know why it matters. What part of his injuries were caused by the actual crash versus what part of his injuries were caused by the impact to the wall? Because whoever's at fault for the crash is also at fault for them going into the wall. So I don't know if they're gonna try to argue in closing something where there is no foundation evidence at all, that somehow Mr. Echevarria is at fault for them going into the wall, even if he's not at fault for the crash somehow. I mean, that would have no basis in the evidence presented in this entire trial.
So I think one of the jurors has hinted to you what they find important for some reason. I don't know the answer to that. That was a juror question, remember? So I don't know what people are thinking. I will ask after every single witness as we go along, as I've been doing, the jurors have any questions, but that wasn't a question that came from them. If that had been a question coming from counsel and there had been an objection, we might have been in a different situation, but we're not in that situation. It was a question coming from the jurors. I don't think that question, I don't remember, maybe it was objected to by them, but not by you. And it was objected by them because they were a little worried that it was gonna trigger biomechanical opinion. For full disclosure, I did not think that that's what was gonna come out of his mouth. I thought he was gonna make a conclusion based on his observations of the body through, I believe, pictures, right? He didn't see the body in person, did he? I don't know when he came onto the case.
He did not see the body in person,
Okay,
you're
so
correct.
that's what I thought he was gonna say. And if you might not want the instruction at all, because it might bring more attention to it, that's a decision to make, but I'm also gonna give a very limited instruction. Like I said, I don't mind saying something to the effect of, he was a medical expert whose testimony beyond a medical opinion, where it got into biomechanical analysis via that last answer he gave, should be disregarded. Okay, you wanna go off for a minute and you guys can talk to each other?
Yeah.
Okay, let's go off the record for just 5 minutes. I know I told. Okay, so we are back on the record, in case A 2184465 We are outside the presence of the jury, but I do have counsel present with me, as well as, Mr. Collins in the courtroom. Okay. So it was my understanding, and I asked defense counsel this when we started, that the injuries claimed are not being disputed as being a result of the accident, right?
Correct.
Okay, so is it just a technical issue that he gave an opinion that might be biomechanical?
No,
Because
well,
opposing counsel's response makes sense. He's basically saying there's no error here even to put that out there. And I don't know if I necessarily disagree with him. I'm happy to give the instruction to fix it, but I also, I hope it's made clear if the defense position is this, that you're not contesting that all the claimed injuries were a result of the accident, that's actually your position.
That's correct, and that was made clear at the beginning of cross-examination. Our issue is the issue that you articulated, which we don't know what value the jury was placing on that question. And we got testimony from someone who's not qualified to give it. So to the extent it's something that matters to a juror, we can't have expert testimony from a non-expert on that issue. And that's why we wanted the instruction read.
Okay, go ahead.
My response is the same, Your Honor, as it was before. If there's an issue that's not in dispute, why does it matter if there's an expert who gives testimony that's outside the scope of their expertise on that issue, because it's not in dispute anyways, so it doesn't matter? I'm really confused why this is so important to defense, and it actually makes me think they're gonna argue something in closing that there's no evidence of, or that contradicts their admission that the crash caused all the injuries.
Well, that would make us look really bad, and I don't intend to do that, and I will go on the record again, as I stated to the witness, that we are not disputing the cause, that the crash caused Mr. Echevarria's death. We are not disputing the reasonableness of medical billing. We are not disputing, and I think Mr. Watson articulated it very well, but I would just add that the response itself about, you know, the first getting crashed by the car and then getting crashed into the wall, not only is it outside the scope of his expertise, it crosses a line into being prejudicial, because the jury is hearing very highly inflammatory things. This is evoking a lot of sympathy. We need to be careful in what we are presenting to the jury and what the opinions they are allowed to hear, so they are not unduly prejudiced by evidence that they should not be hearing. And that is our position. So it may not matter to counsel in the grand scheme of things because of those stipulations, but to us, it is meaningful because the jury found it meaningful, and the jury might find that to be impactful in whatever way they find it to be impactful.
You want to say anything else?
Dr. Hirschfeld also testified about 10 to 20 inches of intrusion through steel and going through.
There was no objection to any of that part. There was
Exactly.
no objection to any of
that
that
was
part.
much more
Okay, let's not.
biomechanical than this. And so our concern, and I mean, our position is still, we don't think any instruction is appropriate. We agreed to work with counsel on this because we thought that Your Honor was advising us to. However, we're concerned that the jury will then see a opinion regarding accident mechanics. They're instructed to disregard it, and in turn they say, oh, well, also what he said about, you know, this, that, and the other, maybe I should disregard that too, because that maybe sounded like it was accident mechanics.
Okay, well, here is the instruction that I have been sent, and I think the last sentence makes it clear what part they're supposed to disregard, but if anybody thinks that it is not clear, then let's clarify that now, right before we bring him in. So here is what I have. The last witness was a medical expert. In response to the final juror question, he provided a non-medical opinion regarding accident mechanics. The witness's response to the last juror question shall be disregarded. I think that's pretty clear what part. I didn't say disregard anything else, and I think you guys can get up and say, she didn't say disregard anything else. Here's what else he said in your closing. They can get up and say she said to disregard this part. So you can't consider that. I mean, I honestly am not sure how it really factors in here at all. If there is an admission from the defense side that all these injuries were caused by this accident, but I thought it was an interesting question from one of the jurors, and we asked it, and I thought it was a fair question because I thought it was going to get a medical response. That's why I asked the question, and that is not the response the expert gave. So I'm going to give this instruction unless somebody has an alternate one or thinks that this instruction is not clear, in that it is only instructing them regarding the last answer that came out of the witness's mouth. Fine?
We're done with our objections, Your Honor.
Okay, fine?
Yes.
Yes, Your Honor.
Okay, so let's bring him in here. Let's ask that. And then who are we putting on next? It's via Zoom. Did you already try it?
Yes, Judge. Yeah, Marie Echevarria. As far as already trying it, no, I don't think we put her up and tested the audio here. I don't know if Your Honor wants to, or should we do that really quick? I presume she's still there.
Yeah, let's do it right now.
We did do an audio test with her through our office a day or two ago, and it worked fine, but obviously.
So can we make her face the biggest one? Is there any way to do that? And who is Myrna? Whoever is Myrna, if that's from somebody's office.
She is.
Okay. Hey, can you say something, Miss Echevarria?
Yes, can you hear me?
Okay, we can hear you. Okay, so we're gonna bring the jury in. If you mind, just we're gonna mute you again for just a minute, or if you can mute yourself for just a minute.
Your Honor, is there any way we can bring the other TV out, or is it?
I have no problem with that. Let my marshal bring in the jury and then have him help bring it out.
Thank
Okay?
you so much, Your Honor.
That's a good idea. Council acknowledge the presence of the jury.
Yes, Your Honor.
Yes, Your Honor.
Everybody can be seated. We are gonna move the TV out for you guys, because we're gonna have somebody testify now via Zoom. Oh, did I read it? I didn't read it yet in front of them. Okay, before this starts, while this is being set up, I just want to give you one instruction about the last witness. The last witness was a medical expert. In response to the final juror question, he provided a non-medical opinion regarding accident mechanics. The witness's response to the last juror question shall be disregarded. Okay. Okay, counsel, are you ready to call your next witness?
Yes, Judge. Plaintiffs call Marie Echevarria.
Okay, Miss Echevarria. Oh, does the TV not working? Is it not going on, or is it just not getting the image?
It's not getting the image, I think.
Okay. Then, look, if anybody else needs to be testifying via Zoom, you need to call ITE before we do it, but otherwise I think we should just go forward. Are you all able to see that? Okay, so can you go ahead, Mr. Chu?
Yes, Judge.
Ms. Echevarria,
Yes,
raise your right hand.
hi. Can you hear me?
Raise
She
your right
can't see
hand.
you. You need to raise your right hand. Thank you.
Thank you. I'm gonna swear you in now. Are you ready?
I'm ready.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under pain and penalty of perjury.
Yes,
Please state and spell your first and last name for the record.
my name is Marie Echevarria. Marie Echevarria.
Thank you so much. You may put your hand.
Counsel, go ahead.
Thank you, Judge. Hi, Marie. Can you hear me okay?
Yes, I can hear you.
Okay, and I believe you'll be seeing me on camera, but if you don't, just the questions will still be coming from me. So just let us know if at any point you can't hear.
Okay,
Where are you testifying from today?
New York,
Where in New York?
the Bronx.
Okay, and is that where you live?
Yes, that's where I live.
How long have you lived in the Bronx?
My whole life,
How old are you currently?
44.
And what was your relationship to Eric Echevarria?
He was my brother.
And were there more siblings than just you and Eric?
Yes, we have an older brother as well.
Is Eric is he the middle or the oldest?
Eric's the middle child.
What was the age gap between yourself and Eric?
He was 12 years older than me.
12 years older?
Yes,
Okay. And how would you describe the neighborhood where you guys grew up in the Bronx?
it was pretty rough.
Um,
The neighborhood.
Marie, I appreciate you trying to raise your voice. If you can just make sure you keep your voice up, just because the audio might not come through.
Okay, it was pretty rough neighborhood.
And did you grow up with both of your parents in the household?
Yes, I did. Yes, we did.
And What did your parents do for work when you guys were growing up?
My father was a custodian and my mother was a secretary.
They work long hours?
Yes, they did.
And growing up, how would you describe your relationship with Eric?
And we were very close. Very, very close.
What
He would
kinds of
pick
things? Oh, go ahead. I'm sorry. Go ahead, please.
he would pick me up from school when my parents worked long hours. He would take care of me. He would feed me, take me outside. We went everywhere together. He was like my protector.
It was like your what?
My protector.
Okay. And
I'm sorry.
no, it's okay. I just want to make sure you're done with your answer.
Yeah.
Any other examples of things you guys would do together?
Go to
On
the
a regular-
park,
Go ahead.
play baseball, take me out to eat, take me for ice cream. We just did everything together. I was with him a lot.
Was Eric involved in your schoolwork at all?
Very much involved in my schoolwork. In activities, I played softball. He was there all the time, every game, cheering me on, there. He was always there.
And as you got a little older, maybe say junior high years, early high school, how was your relationship with Eric at that point?
It's still the same. Eric left to California when I was 13. I mean, he was far away, but the phone calls were never that far away. We would speak to each other every day.
So when you were, go ahead.
He came back for a little while, stayed with me and my parents. After that, he went back to Vegas when I was like about 17.
So when you were around 13, Eric moved from the Bronx to California, you said?
Yes,
What was that for?
for work. He was in the Army.
And then he came back to New York, and then a few years after that, he moved to Vegas permanently, it sounds like.
Yes, he did.
Did you continue to have a relationship with Eric after he moved to Las Vegas?
Yes, I did. Of course.
Can you explain that to us? How frequently would you talk, or how did you guys maintain a relationship being on different sides of the coast?
Okay.
Oh.
We would talk every day. Every single day we would talk. Nothing changed. The only difference is that he wasn't in New York anymore. So we didn't spend as much time as we used to. But from time to time, I would go out there when he was in California. And when he came back, like nothing ever changed. Hanging out again. And when he decided to move back to Vegas, it just the same thing, talking on the phone, going out there to see him. We was just very close.
Do you have any kids yourself, Marie?
Yeah, I have 2 kids.
Did Eric have any type of relationship with your kids?
Yes, he did, especially my daughter.
Can you tell us about that?
They were very close. He was like a father figure to her. When he passed away, it was devastating for her. My daughter changed significantly. She got depressed, her anxiety. She was devastated.
At some point, did you meet Anne Marie?
Yeah, I did. Yes, I did.
And how would you describe Eric and Anne Marie's relationship based on your observations?
They had a great relationship. They loved each other very much. They were always together. You see one, you see the other.
I'm sorry, what was the last thing you said?
You see one, you see the other.
Oh, you see one, you see the other, okay. And at some point, did you come to learn that Anne Marie was pregnant and that they were gonna be having a little boy?
Yes, and we were all ecstatic. We were so happy for them. Because my brother loved kids. That's just who he was. He was always around kids. They loved him and Anne Marie's kids as well. Those were his kids as well.
How would you describe Eric's relationship with Eric Jr.?
They had a great relationship. My brother was always with his son, and he loved his father. Every time I would speak to Eric, little Eric was right there, taking him to the park, taking him to Sky Zone, taking him to get McDonald's, always in his life, just there. School projects, school plays. Every time I spoke to Eric, little Eric was there. He was a great father.
When was the last time you spoke to Eric? Eric Sr.?
The last time I spoke to Eric was 2 days before my daughter's birthday. My daughter's birthday was December 29th, and he died the next day. And I spoke to him on the 27th because I was telling him I had a little financial struggle with getting my daughter a birthday cake. And without hesitation, he just sent me the money. He said, "Here, don't worry about it." And that's the last time I spoke to him.
And that was, I think you said 3 days before he passed?
Yeah, yes, 3 days before he passed. I miss him very much.
Yeah, I'm sure you do. I'm sorry to hear for your loss.
We all do. Has no idea what this loss has done to my family.
And Marie, I'm going to ask you about that a little bit, and I'm almost done with you. I know this is not easy. What are your impressions of the way that Eric's death impacted Anne Marie?
She's not the same person anymore. She's not the same energetic, bubbly person she used to be. I mean, she tries, you can tell. I speak to her on the phone. She sounds so sad, so distant, not really wanting to talk, you know. My nephew's so disassociated. Like he completely shut down.
You're talking about Eric Jr. As to the last portion of your response?
Yes, I'm
Okay.
talking about Eric Jr., my last response.
And when you say he's disassociated or he completely shut down, what do you mean by that?
He just doesn't talk about anything. Doesn't really talk about my brother like that. He doesn't want to talk about it. I barely could talk to him on the phone because he doesn't want to really speak.
Emery, I'm sorry, Marie. I don't have any
Yes.
more questions for you. I really appreciate you appearing and testifying for us. I'll pass the
Thank you
witness.
so much.
Marie, my name is Stephanie Zinna. I represent Zaon Collins. I'm very sorry for your loss. I don't have any questions for you.
No questions.
Do any of the jurors have any questions for this witness? If so, please write them on one piece of paper and write your badge number on paper and give it to my marshal. Okay, I'm not seeing anybody writing or raising their hand. So I'm gonna assume there's no questions. Ms. Echevarria, thank you very much for being here.
Thank you.
But we don't have any more questions for you. Have a good day.
You too.
So are there, are council prepared to call any more witnesses today?
We are not, Judge.
Okay, so at this time, I'm gonna release you for the evening with instructions to come back tomorrow. We're gonna do a later start tomorrow and ask you to please come back at 1:15. Okay? So please have lunch before you get here, because we're not gonna have a lunch break. You're only gonna have like a one break in the afternoon for something in the range of probably 15 to 20 minutes. So you'll have like basically a coffee / restroom break, and that's it. But like I said, 1:15 tomorrow. You're instructed not to talk with each other or with anyone else about any subject you're connected with this trial. You're not to read, watch, or listen to any report or commentary on the trial by any person connected with the case or by any medium of information, including without limitation, newspapers, television, internet, or radio. You're not to conduct any research on your own relating to this case, such as consulting dictionaries, using the internet, using reference materials. You're not to conduct any investigation, testing theory of the case, recreate an aspect of the case, or in any other way investigate or learn about the case on your own. You're not to talk with others, text others, tweet others, Google issues, or conduct any other kind of book or computer research with regard to any issue, party, witness, or attorney involved in this case. You're not to form or express any opinion on any subject connected with the trial until the case is finally submitted to you. Okay, with that being said, you are dismissed for the evening. We will see you tomorrow at 1:15, please. All right. Okay, everyone can be seated. The council want to make any other records at this time? Plaintiffs' counsel,
No, Your Honor.
defense counsel.
Yes, Your Honor. I just do have a concern now that we've had two character witnesses that we're calling two more tomorrow, and where these two witnesses that were presented today were substantially similar in their testimony as to their impressions of the family. And I believe after tomorrow, we still have more character witnesses after that. So it's just our position that we're gonna start wading into cumulative and overly prejudicial testimony by asking these witnesses and eliciting the same testimony. I wanted to place that on the record that I'm now seeing a concern.
Do you want to say anything?
Yeah, sure, Judge. We have two more that we intend to call both tomorrow. We don't intend to call any additional character witnesses beyond that, just some. Yeah, just the party, our clients themselves, and then the another expert, but only two more character witnesses. Each character witness has testified for I don't know, in the range of 25 to 35 minutes. Obviously, there's going to be some overlap. We briefed this issue extensively. The case law talks about that, how naturally there's going to be some overlap. But when we are presenting witnesses who are offering perspectives about the that lend insight into the value of the decedent's life and the impact on the heirs from different perspectives, then it is not cumulative simply because there is overlap as to fundamental aspects of their testimony. I don't expect anything different from the remaining two character witnesses in terms of the length of time, and we're not going to have them harp on the same points over and over again.
All right, defense, you want to say anything?
I would just stand by the objection as to all character witnesses. I am unaware of any others that are or not be called, but Moses Robledo would certainly be duplicative of the witness we heard from today, whose name was something else. Robledo. Jason, thank you. Jason Robledo. So we're who I imagine is another stepson of the family. So that would be duplicative. So again, just for the record, it's beginning to get cumulative and concerning in that respect.
Okay. So I did get the briefs, and I also got a pretrial memo that simply had, I believe, a list of witnesses without any description as to what each specific witness was going to offer in the way of testimony. So, and I'm talking about page 17, witness to be presented. And it's just a list of the witnesses with their contact information without any description of what each witness is going to say and why each witness is being called. So I guess like my issue would be, what happened at the 2.67? Was there discussion about this? Because I can't guess what anybody's going to testify about. So although I appreciate the thorough briefing, what am I supposed to do? Guess that these people are supposed to offer certain testimony because that's what you present it to be, or that's what you present it to be at this point? I mean, if you're offering, I can't even tell by the list that was provided in this pretrial memo, who's gonna call which witness. So, I mean, at the end of the day, that's a large reason why I frankly didn't offer you rulings on what I know counsel believed to be a very well briefed issue, because it's not a well briefed issue. I don't know what anybody's going to testify to based on the joint pretrial memo. There's no description after their names. There's contact information after their names, but there's no description. So what do you guys want me to do? Guess? It's a joint pretrial memo. You both signed it, right?
We did, Judge.
What was the plan? That I was supposed to guess what each person was testifying to?
Judge, we did provide a bit further description in our response to defendant's trial brief regarding cumulative testimonial evidence filed on May 1st, which provides a little bit more detail as to each character witness. But I mean, if Your Honor would like, I mean, if we were to bring Mr. Robledo in, and if you.
I mean, I told you
question-
guys, these issues, sorry to cut you off,
Are you okay?
but before each person testified, I don't know what they're gonna say. Whatever you guys discussed at your 2.7 is what you discussed at your 2.67. So I imagine at 2.67, you said, I'm gonna call Marie and she's gonna talk about whatever she's gonna talk about. I'm gonna call Carlos and Carlos is gonna talk about whatever Carlos is gonna talk about. I'm gonna call Ashley and I'm reading the names off. Ashley's gonna talk about whatever. So, I mean, the proper step at this point, because it could have been done to motion limine, wasn't done to motion limine, is, and the motion limine, I guess you could have given me your disclosures, because I'm assuming these people were all disclosed well in advance, right?
They were,
And
Judge.
I'm assuming your early case conference disclosure had a description as to what this person each offered, right? That's usually normal too. Otherwise, I would have assumed I would get a motion from somebody to exclude them because we don't know what they're gonna say. So none of that is here. So before each person testifies, then make your objection. So who's tomorrow?
The defendant, Marvin Collins.
Okay, is there an objection to Marvin Collins being duplicative?
No.
Okay, who's next tomorrow?
Moses Robledo is the oldest stepson, so his perspective is unique, Judge, in that because he was older at the time that Eric came into the picture and started dating and then marrying his mom. He has a lot more to say in regard to specifically about Anne-Marie and Eric's relationship. He was, a young adult basically when they first started dating, I believe, and so he had a lot more mature perspective on their actual relationship and the impact on his mom, as opposed to, for instance, Jason, who testified today, who grew up with Eric, whereas Eric came in and basically played a father figure to him and taught him how to throw a baseball and so forth. Moses was already more or less grown. After that, we have Rigo Munoz.
So, okay, let's stop there.
okay.
So is there an objection to Moses?
Yes, there is.
Okay.
And I pulled up plaintiff's disclosures, just, so we can clear up the record here.
Do I have a copy of this? What's the date on what's the file stamp on the top right?
I pulled up their 12th supplement. I don't know if it's the most recent. Wait, let me pull up, maybe there,
Is it a file document?
yes, it is.
Okay,
Or it's a electronically served document.
okay, I can't see served documents.
February 25th, 2025. Where every character witness states who the witness is in relation to the decedent. And then the blanket language, they are expected to testify regarding the knowledge of plaintiff's life and character before the subject crash, how the crash has impacted plaintiff's family and any other matters pertinent to thereto. So while I acknowledge that Jason Robledo and the decedent's sister, were not objected to witnesses in that sense, but now, like I stated, Moses, we're getting into new territory. Just because he had a different relationship with the decedent doesn't mean that he isn't going to duplicate testimony regarding Eric.
What page of the
Echevarria.
document are you on? I pulled up the document filed on February 25th, 2025. What page are you on of it? That has the description.
I was just reading from, I pulled up page, it doesn't really matter, but I pulled up page 5, for instance.
Page 5 has a description of what they're gonna testify to?
As a picture of plaintiff's disclosures, not the pretrial memo.
I'm holding plaintiffs, I think I'm holding plaintiff's disclosure. You said filed on February 25th, 2025, right?
Correct.
Okay,
So if we look at, say, for instance,
I still don't have descriptions next to any of these witnesses.
oh,
Are you holding something that actually has, like, generally, the
Yes.
disclosure has the witness's name and then underneath this person is gonna testify, I mean, sometimes it's super general, like the facts and circumstances surrounding the accident.
Right, so this
Okay.
one, it says, for instance, Jason Robledo is plaintiff Anne Marie Echevarria's son and is expected to testify regarding his knowledge of plaintiff's life and character before the subject crash, how the crash has impacted plaintiff's family and any other matters pertinent thereto. So each witness has that language beneath it, identifying who they are and the same language for each of them. So
That document was filed in this case?
no, it's just.
Oh, I don't have a copy of that document.
Okay,
Okay, so, yeah.
So based upon that,
Mhm.
you know, plaintiff had listed out several witnesses, and I think they have cut it down. That we, I think, touched upon in the EDCR 2.67 conference. However, we didn't go, I don't believe we really went into depth as to how that was handled. We filed the bench brief just to say, look, we understand you get a couple of these, but we're gonna start objecting as we get to cumulative or overly prejudicial testimony, because we didn't depose these people. I don't know what they're going to say. So I didn't think it was appropriate to file a motion in limine to exclude them entirely. But now the objection is, at least as to Moses, it's getting duplicative. And I would hold that objection. I think Rigo offers something different because he was a coworker. And then if you're not calling anybody else, then that solves the issue.
That's our plan as of now. Bless you, Judge.
And bless you.
Thank you.
Said it first.
Okay, so no problem with Rigo, potential problem with
Moses.
Moses, because you think Moses is gonna say the same thing that Jason said, right?
Correct. I mean, he might know Eric differently. Bless you.
It's fine, let's keep talking, it's okay.
He might know Eric differently, but he's still in the same family unit and is going to have the same or similar impressions of the family and how. And he gets to be duplicative.
Judge, we've called 2 character witnesses. This started with an allegation that we had 50-something, and then we had a list of, I don't know, 17 or 18 total witnesses, maybe half of whom were character witnesses in the pretrial disclosure. We've called 2, and we're talking about calling 2 more, one of whom is a coworker, so he presents something from a far unique testimony, unique perspective as compared to the ones that who testified thus far. Again, like you said, this was not raised in the 2.67. This was not raised as a motion. in
Oh, it
limine.
wasn't raised in 2.67, you guys didn't talk about the 2.67, or you did?
Generically, but if there were concerns at that point, because we did have our witnesses, laid out at that point, then that could have been, proactively addressed at that stage. And certainly as a pretrial motion. And, we filed a lot of we inserted a lot of case law in our brief. I'm not going to go through all of it. I just want to mention one case, Judge, because it's quite appropriate here. We have to drift outside of Nevada for something this nuanced, but Cedarblom versus United States, it's a federal case from the Southern District of California. The court denied a pretrial motion to exclude testimony of 13 lay character witnesses, citing the fact that the plaintiffs insistence that each of their witnesses can and will testify about different particular facts concerning the plaintiffs. And in that case, the defense complained about the fact that the pretrial disclosure just listed these generic descriptions of testimony, that they couldn't gain any insight from how these witnesses were going to be different. And what the court noted was that the defendant had the opportunity and elected not to depose any of plaintiff's proposed witnesses.
Let me ask you a question. When did you disclose these witnesses to defense with a description of what they were gonna say at trial? Because that hasn't been disclosed to me in any disclosure, but when were your early case conference productions done, and how early have they known about these people and what they were gonna say?
The judge, for each of the ones who have testified, or for Moses or Jason in particular, I have to go through and look. I don't know off the top of my head.
Years
And
ago? Months ago?
Rigo would be years ago.
for Rigo, it would be years ago, maybe
Well, I thought they had no problem with Rigo.
Okay.
Yeah, I don't
Rigo,
have
you
a
got no
problem.
problem with, right?
Moses was disclosed February 26, 2025 in their last supplement.
Okay, so Moses was just disclosed recently.
And the
But
ro-
Jason was, Jason's done, the objections waived it because he came and went and done. Okay, so Moses is the problem, is what you're saying right now, you think
So I-
Moses is gonna be duplicative of Jason?
Correct, Your Honor, that's the objection.
But it's just conjecture, Judge, as to whether or not he's gonna be duplicative. I mean, I'm representing as an officer of the court what he's going to testify to. Obviously, there's going to be some overlap. But we know better, not just because we're violating the rule and upsetting, the court.
How's
but
he not gonna be duplicative? Tell me what he's gonna say that's different than that was his brother, right?
So Moses is 39 or 40 years old. So he was considerably older when Eric came into the picture. I should note it here, but I believe he was already an adult legally or very close there too.
Okay,
He had because their biological dad wasn't in the picture, he had a very close relationship with his mom, kind of having somewhat of a, supervisorial, fatherly to some degree role within the house with all the younger kids. When Eric came in, Moses was able to view and appreciate the relationship that Eric had with his mom and the relationship that Eric had with his little siblings in a way that was much different from, for instance, someone like Jason or someone like Eric Jr., who's going to testify on Thursday, where they were actually being raised by Eric as their father figure. Moses was already raised, Judge. And again, we're talking about 25 minutes of testimony, maybe. We don't want to inundate the jury with the same testimony. We know better than that. So, Your Honor, I think it's conjecture for them to just say it's duplicative because they come from the same family union.
okay. The actual parties in your case, Anne Marie, the estate, and Eric Jason Jr., right?
Correct.
Okay. Did Eric adopt either Moses or it's Jason, right?
Oh, Your Honor.
No, okay. What do we get out of Moses's testimony that we are gonna hear from Anne Marie, right?
We are, Judge.
That Anne Marie isn't already giving us, or that Jason isn't gonna give us. I guess that probably more appropriate that Anne Marie is not gonna give us, because Anne Marie was around for all the time Moses was, right?
Certainly.
Yeah, so what does Moses offer that Anne Marie can't give us?
Are you, go ahead.
Moses corroborates testimony from Anne Marie about Eric, how important he was to the family, how
Okay.
important he was from Anne Marie, or for Anne Marie, how he raised Eric Jr. He gives an outside perspective that is not a plaintiff, Your Honor.
Are you gonna challenge any of those things?
No.
Okay, so if there's absolutely no challenge to those,
Whether it's challenged or not, Your Honor, I think it's important for the jury to hear the testimony from a different witness because it corroborates it. So even if defense counsel, for example, doesn't challenge it, the jury we're entitled to present to the jury different perspectives. I think the case law is clear on that.
but you've already got Jason, you're gonna have Eric, you're gonna have Anne Marie, you're gonna have the coworker, I'm sorry, I don't remember his name.
Rigo Munoz.
Just a minute ago. And you're gonna have various other people.
We are not, Judge, besides Rigo.
Oh, you're not?
That's
Okay.
what we're saying is.
You've already
we have-
cut it way down.
We have a few other character witnesses who are listed. At this point, we don't intend to call any others besides the two that we have for tomorrow, one of whom the defense does not object to. But again, this is a death case of a 53-year-old, and we're talking about our third character witness running to maybe an hour and a half of total testimony.
But we just got defense saying, and you'll be able to say, there's absolutely no challenge to this guy and who he was and the stuff that they're gonna put forward, right?
Well,
To how important he was to this family, to how valuable he was to this family, to his role in this family. You're not challenging any of that stuff, right?
We're not.
We're not, no.
Well, there is a challenge, Your Honor. They can't say they're not challenging it because they're challenging our number. In order for us to present different evidence on numbers, they're gonna say, oh, well, you heard this testimony, you heard that testimony, it's worth this much. We're gonna say, you heard this testimony, it's worth that much. We're entitled to present different perspectives because the jury needs to hear that in order to give them a foundation for the number we're gonna ask for, Your Honor.
Are you gonna challenge the final number they're gonna give?
Of course, Your Honor. I mean, not as far as the medical billing. But the loss of consort, I mean,
I'm gonna allow the witness, be reasonable though, okay? This
Thank
isn't
you.
gonna go crazy. You can make more of a record later. But if there is gonna be a challenge as to the numbers and they wanna, if it starts to go into the exact same stuff that his brother was saying, object, and I'll sustain. And that's, you guys need to understand too, they're not challenging the content of this as I see it, okay? And now, because they're going to challenge the value, for lack of a better term, as disgusting as that sounds to call it a value, but because they're gonna challenge the value of it, I will let you put these witnesses on, but be reasonable. Watch the repetitive stuff, especially in light of the fact that they're saying, for the record here, they're not gonna challenge the content of it,
Understood, thank you.
okay?
And it's just one witness at
And
this
we've
point.
got nothing in this situation where there's abuse or something that is coming out of somewhere, right? Because after I'm excluding some of this and limiting some of this, if in your case in chief, you pull something out that does challenge all this, that's gonna change this game. I mean, for lack of a better way of phrasing it, that's gonna change this situation, and that's not the impression I'm getting from you guys right now. I'm not trying to make you reveal your whole case, but because you're trying to limit their case and their case in chief, if
I-
there's something that's gonna come up in your case in chief, that's gonna, for lack of a better description, blow theirs out of the water because it's just so contradictory, they're gonna get to come back with rebuttal and call every single one of these witnesses if they want to.
I am unaware of any witness either in plaintiff's case in chief or in my case in chief that will dispute that Eric was nothing but a husband, father, and a stand-up human being.
Okay,
We, our focus is more on the crash itself and the reasonable damages resulting therefrom, not who Eric was as a person.
okay. Okay, so in light of that, I'm gonna let you, because of the challenge to the value of what was lost, I'm gonna let you bring your witnesses, but within reason, okay? And then, like I said, you can have a lot of these people on deck for rebuttal. If anything comes up in their case in chief, which they're telling me it's not going to, but if anything comes up in their case in chief, you can have them on deck for rebuttal,
Understand, thank you.
okay?
Understood, thank you.
Understood, thank you.
Okay, anything else you guys wanna go over before tomorrow?
I don't believe so, Your Honor.
Anything from us, Your Honor?
Yeah, and we think tomorrow, I mean, if the witnesses are on top, are, ready to go and we don't have any, major issues outside the presence, there's a good chance we will end in similar time tomorrow as well.
I think that would be nice, and the jurors would appreciate that, but also, if you're gonna end up this time tomorrow and you think you have a witness that's only gonna be half an hour, let's put them on.
I mean, it would just be another character witness, we could throw them
Ah,
in there. I mean,
Okay. Okay, and you told them who's gonna be here tomorrow, right?
Yes, Your Honor.
Yeah.
we
Okay,
did,
go.
I mean, we didn't talk about it, what order, but they know the witnesses and I don't think we decided what order, so.
Okay. So, if anybody's gonna be via Zoom, come early and make sure it all works. You can come early and play with the TV if you want. Otherwise, I'll plan to be in here at 1:05 for anything that we need to do before we bring them in at 1:15.
Thank you, Your Honor.
No one via Zoom.
All right, thank
Okay,
you, Your
thank
Honor.
you guys. Have a good day. There is gonna be people in here tomorrow morning, so
We'll move
you
everything.
can leave your stuff in here, but just put it along the wall, okay?
Understood, thank you.
Thank you, Judge.
Yeah.
Feel better.